5 critical factors for college tuition and child support. Port and Sava, attorneys at law. College tuition and child support are related but not the same thing. The child support law is mandatory, but payment of college tuition is discretionary. The court could order it, or the parties can agree to it in a settlement. The starting point is the Child Support Standards Act, CSSA, which helps figure out how much child support should be paid. What's interesting, though, is that it doesn't specifically say anything about college tuition. The statute allows for the court to order payment of college tuition, but it does not require it in all cases. The court looks into whether the child is actually planning to go to college, alongside other factors like how much money the parents have, how well the kid is doing in school, whether the kid can chip in, and what the parents' views on higher education were before they split up. For children of divorced parents, college costs are often tackled using what's known as the SUNY Cap. This isn't a law, but a handy method lawyers use to limit how much each parent has to pay, based on the cost of attending a state university in New York. If parents can't agree on who pays what for college, the custodial parent can take the issue to family or Supreme Court to ask for help with the tuition from the non-custodial parent. The court can also make sure the non-custodial parent helps out with the FAFSA. College expenses can include tuition, room and board, fees, transport, books, healthcare, and other living costs. In New York, when it comes to deciding on college expenses, courts consider a bunch of important factors. Parents' finances. The court looks at each parent's ability to contribute based on their income and assets. The kid's school performance and needs. The court checks out the child's education goals and resources like financial aid. Family expectations. The court thinks about the parents' education levels and what the family expected about college before splitting up. Relationship with the non-custodial parent. The court might consider how the child and the non-custodial parent get along. Cost of college tuition. The actual cost of tuition plays a role in the court's decision. The court tries to balance the child's needs with what the parents can afford. Divorcing couples should consider seeking legal advice regarding the SUNY Cap and college payment responsibilities. In New York, parents can ask the court to change the child support order, including college expenses, if there's a big change in their situation. In New York, even if parents were never married, a court can order a non-custodial parent to help with college tuition. Child support ends when the child turns 21. The court is without power to order a parent to pay college tuition and child support after 21. But if the parties agree to extend the time, the court does have the power to enforce that agreement. Many times, parties will agree to extend the non-custodial parent's obligation to pay for college tuition and child support until 22, or then the child graduates a 4-year program. If a non-custodial parent pays for room and board, he or she may get dollar-for-dollar credit on the child support. There are limitations. If there are other children under 21, then there is a more complex calculation. Also, the non-custodial parent needs to be aware of what constitutes room and board. It is only rent and food. It is not gas money, tolls, cell phones, or other incidentals. Never take the dollar-for-dollar credit before consulting with a lawyer. Call Port and Sava at 516-352-2999 for a free 15-minute consultation.